welcome to another live session of Franchising with FASA. Joining us today is Mari Jonker from Smit & Van Wyk. We're going to be discussing the topic about franchise agreements and the implications, especially with this pandemic and the lockdown and how it's disrupted everybody's lives. I mean, people have now lost incomes, people have had to close their businesses, they couldn't operate. And if you're in a situation where your business has been locked down and where things are happening, and especially when you've got commitments to landlords and commitments to say your franchise, especially in the franchise sector, lots of things can go wrong. And sometimes it's easier for us to avoid things than to face things head on. Let's ask legal how to best deal with obligations and commitments that we have agreed to with good intentions, never expecting anything like this ever to happen, a world shutdown. So hello and welcome, Mari. Thank you for joining us today.
Hi, Romany. Thank you very much. It's good to be with you today.
Good. So quickly, before we start, Smit & Van Wyk specialize in intellectual property law, patents, designs, trademarks, copyright, licensing, franchising, and related commercial aspects. Mari Jonker also sits on the membership committee for the Franchise Association. So let's get started asking some questions. What are the obligations with regards to the franchisor's obligations and the franchisee's obligations and commitments? What are the rules, the responsibilities, the commitments? How does it work?
Romney, I think all franchise businesses, they were exposed to severe difficulties and unforeseen circumstances caused by the COVID-19 pandemic. Now, if we have a look at the problems or the trading difficulties, it is very important that the franchisor and the franchisee work together. The franchisee, yes, like you've said, they've got obligations in terms of the franchise agreement to operate the business and to be involved in the business and to trade. Whilst on the other hand, you've got your franchisor who is the custodian of the franchise brand and who needs to protect the brand. When the parties are faced with trading limitations or restrictions in terms of government regulations, it has been caused as a result of no fault by any of the parties. And it is very important when you are faced with situations like this, which you did not foresee or which you did not even address in your agreement, what are you going to do if there is a pandemic? Then it's very important that the parties discuss what are they going to do. The parties should identify the difficulties. They should acknowledge and admit what can they do, what they cannot do, what are the restrictions, and how are they able to overcome their restrictions. For example, the business system may change, or they may adopt a business system. If you have, for example, a system, a restaurant, a sit-down restaurant, the parties may decide, let's do online orders, let's do delivery orders. But that will have a direct impact upon the business system as described in terms of the franchise agreement. So the parties can sit together, they can discuss, and they can see how they can overcome difficulties. If they need to make changes to the business system to, for example, generate more income or to enhance trading amidst the limitations or the restrictions, it's very important that the parties then record that interim arrangement or perhaps permanent amendments to the business system. So in other words, if there's an existing business system and changes will be made to that business system, it is important that the parties then agree whether they're going to have interim amendments or changes or whether they will adopt permanent or long-term or medium-term changes. And then those changes should be agreed upon, and then the parties should then be certain what they've agreed upon and be certain in terms of the specific changes which they have agreed upon to overcome the trading difficulties.
Now, when it comes to landlord agreements, how does one get help for that, or what should one do or think about? Because obviously, the landlords need their money. They obviously got commitments and bills that they need to pay, but, and the rent has to be paid. How does this work with regards to where people find themselves in situations where they're not operational?
So in terms of South African law, we need to have a look at the relationship between the parties, the franchise agreement, which will primarily govern the relationship between the parties. If the franchise agreement makes provision for a force majeure instance, or if there's a situation where the agreement explains what you need to do in the event where the parties may not be able to perform as a result of no fault of their own, one have to look at the agreement, and you need to determine what does the agreement say, how are we going to regulate, or how are we going to address this issue. If the agreement is silent on this, we need to have a look at the law of contract in terms of the common law, and in our law we refer to it as supervening impossibility. In other words, the parties are not able to perform as a result of no fault of their own. So we need to consider, first of all, your franchise agreement. Then we also need to consider your lease agreement in terms of whether there are specific provisions related to force majeure, and if not, then we rely upon the common law supervening impossibility principles, which will apply. But it is very important that you look at the specific circumstances. You also need to have a look on the restrictions. Are you restricted in terms of your lease or in terms of your franchise agreement to only do one specific portion of your business? Or are you restricted not to do anything? You can't do anything at all. And one needs to have a look at the specific circumstances, then evaluate it based upon your agreement, and then make a decision on what can you do to limit your own damages, and what can you do and negotiate and communicate with the other party towards whom you may have a payment obligation towards. Romany, it's very important. One should keep in mind that the fact that there may have been a state of disaster declared in our country, all relevant legislation still remains in place. So in other words, if you have signed a franchise agreement, or if you're going to enter into a franchise transaction, it's important to make sure, franchisors and franchisees, to remember that the parties are still bound to the legislation and to the ordinary principles which will apply to the relationship. In other words, if a franchisor is going to enter into a franchise transaction, the franchisor should still supply and provide the franchisee with a disclosure document and with a franchise agreement as prescribed in terms of the Consumer Protection Act. So although we may be in the middle of a disaster or in the middle of a pandemic, the parties are still subject to the legislation and to the normal principles or legal framework which will apply in as far as franchise transactions are concerned. So if we have a look on what financial information should be provided to a franchisee, we know that the Consumer Protection Act states that each and every prospective franchisee should be provided with a franchise disclosure document by the franchisor. And in the disclosure document, there should be financial projections. Likewise, in the franchise agreement, the franchisor should set out the total investment required by the franchisee, or what is expected to be paid by the franchisee in terms of initial and ongoing payments. So if we have a look at financial obligations, even though there's a pandemic, one should consider this as well. Franchisors should have a look at their financial projections in their disclosure documents, and they should also have a look at the financial obligations in their franchise agreement. And one should align this with projections and with payment or financial obligations now when we are in the middle of a pandemic, or when we are subject to certain restrictions or trading limitations. In other words, if financial projections are provided to a new franchisee, I would recommend that the franchisor states whether those projections are pre-COVID, and then also provide an indication of trading figures or trading activities in the middle of COVID. It would not be correct to provide the franchisee with information, and that information only relates to pre-COVID figures, because that will not be a true reflection of what's happening now in the middle of the pandemic. And please keep also in mind, in terms of the Consumer Protection Act, a franchisor should provide the assumptions on which those financial projections are being made. On the franchisee side, I would recommend that the franchisee specifically request information from the franchisor in terms of trading pre-COVID and trading in the middle of COVID. So it will make a difference, because trading pre-COVID and trading in the middle of COVID, it is not the same. So the franchisee should be fully informed of what trading was before COVID, or if a business is sold now to a franchisee, the franchisee should understand the impact of COVID and how it may impact his business in terms of financial viability. It is also important that additional franchise costs, for example, COVID compliance, sanitizers, COVID compliance officers, additional staff costs, protection. It is also important that the franchisor factors in additional cost which the franchisee must be. It is also important that the franchisor considers additional cost in relation to COVID regulation compliance in its franchise projections and in its franchise agreements. For example, there are a lot of additional costs which a franchisee may need to incur as a result of COVID compliance protocols, sanitizing, additional staff which may need to be appointed to ensure compliance, or COVID marketing material, COVID notices, all those kind of things, additional PPE, all those things may have a cost implication. So those additional costs should be factored in when a franchisor provides a new franchisee with financial projections, and if the franchise business is being sold or the franchise transaction is being entered into at this point in time during the pandemic.
So much to think about, so much to consider. Wow, it's just, gosh, if we don't have already enough on our plate, and there's so much more to consider with regards to this pandemic. Can I ask you, is there any final thoughts you'd like to share in terms of the information that you shared with the audience today? Also with regards to perhaps new systems, new tools, because, sometimes we might have a business that could be not moving with the times, or a business that's perhaps in need of reinvention. What are your thoughts on that?
Yet again, I think it's very important that there will be active and constructive communications between a franchisor and a franchisee. The whole COVID-19 pandemic resulted in many businesses being innovative and adopting new business methods. So for a franchisor to keep in time with the changed environments, or to be in line with changed environments, it may be necessary to bring about certain changes to the business system. At the end of the day, like I said, there's a balance of interest. A franchisor needs to protect the brand. However, the franchisor also needs to make sure, although it may not be in the agreement, but a good franchisor will make sure that it keep ahead of times, and that it provides the franchisee with assistance and support and with innovative alternatives to enable the franchisees to continue with trading amidst all the restrictions and the trading limitations. It should also be noted that certain restrictions and limitations imposed by COVID regulations may really limit the franchisor's ability, and sometimes the franchisor cannot do anything about it because the business system is of such a nature that it cannot be amended or changed. But in such instance, yet again, it's important for the parties, the franchisor and the franchisee, to have constructive discussions about this, to see if they can include or bring about other elements into the business system as part thereof, or to develop or enhance their system so that there may be some sort or some form of growth or some sort of product development, which will at the end of the day secure the sustainability or the longevity of the franchise group.
Thank you so much. Out there for watching, if you have any questions or you want to ask Ismarie a question, you can pop your question either in the comment box below, but we will also be including a link to be able to contact Ismari Jonker of Smith & Van Dyk. So once again, just a reminder to everybody in closing that FASA is a non-profit organization who is there to protect and lobby and promote ethical franchising across all sectors in South Africa with a specific focus on transformation. If you would like to know more about what FASA does and their products and what they offer, from franchise manuals to books that you can buy, you can also find out about membership and online events that we host regarding to franchise opportunities. You can visit FASA at www.fasa.co.za. Thank you, everyone. Thank you for watching.